Today, I'm going to identify several scenarios where a Canadian can avoid paying their debts. You might be worried that your creditors are going to sue you and that you might have to pay monies to your creditors. You might be concerned that your creditors are going to place a lien on your property, garnish your wages, or seize your property or monies in your bank account. In Canada, there are certain categories of income that are beyond the reach of your creditors. Furthermore, depending upon your situation, some or all of your assets might be beyond the reach of your creditors, particularly for low net worth individuals. You might be judgment proof or near judgment proof, in which case, regardless of how much money you owe, you can avoid paying monies to your creditors. Hi, I'm Mark Silverthorn. I hope you enjoyed this video. Today, I will be sharing with you my insights gained working as a collection agency lawyer for 12 years for some of the largest collection agencies operating in Canada. I manage the legal department at a number of collection agencies. I am very familiar with how creditors and their authorized collection agents attempt to recover unpaid accounts from consumers. My goal today is to help you identify those scenarios where certain assets and some types of income are beyond the reach of your creditors. I am also going to provide you with some tips for gaming the debt collection process. Before I describe the assets and income that are beyond the reach of your creditors, I'm going to provide you with a quick overview of how creditors attempt to recover monies from consumers. If your creditor cannot recover an unpaid account from you after months of making collection calls, then it might decide to sue you. If one of your creditors successfully sues you and obtains a judgment against you, then your creditor does not magically receive money from you. You are under no obligation to voluntarily give money to a creditor that has successfully sued you. If your creditor successfully sues you for non-payment of a debt, the onus is on your creditor to recover monies from you. The more information that your creditor has about your employment and your bank accounts, the easier it is to recover monies from you. If your creditor has obtained a judgment against you, then it is legally entitled to examine you at a court-appointed location, at which time you are obligated to answer questions under oath about your assets and your income. Creditors pay the costs associated with these examinations, so they are not common. If your creditor does not require you to attend such an examination, then it is critical that you do not disclose the name of your employer or the name of your financial institution and your bank branch where you have a bank account. Furthermore, the name of your employer should not be available on social media to your creditor or its collection agent. Once a creditor has successfully sued an individual, it can attempt to take advantage of a number of extraordinary remedies to recover monies owing to it. The most common ways for a creditor to enforce a judgment are as follows. Creditors prefer suing debtors who own a home or real property and are reluctant to sue renters. Some Canadian banks will sue homeowners for amounts as little as $4,000. Make no mistake, if you own a home, townhouse, condo, cottage, or rental property in your name, then your creditor will be drooling because it can simply sue you, obtain a judgment, and slap a lien on your property. It will then recover its monies plus interest when you mortgage or sell your property. Alberta, unlike other provinces, has a $40,000 exemption for a principal residence. So Alberta homeowners with relatively small debts might not have to worry about having a lien placed on their principal residence. If you are employed, then your creditor can obtain a wage garnishment through the courts and receive a portion of your wages. The exact amount that a creditor garnishing an individual's wages is entitled to varies from one province to another. There is a link in the description to an article on my firm's website, debtcoachsilverthorn.ca, that sets out how much of a debtor's wages are exempt from garnishment in each province and territory. Your creditor cannot garnish your wages if it cannot identify the company for whom you work. If your creditor can identify the name of your financial institution and your branch where your bank account is located, it might be able to seize the monies in your account utilizing a garnishment of your bank account. If your creditor successfully does a garnishment of your bank account, then it is entitled to seize 100% of the money sitting in your bank account up to a ceiling where the judgment amount is satisfied in full. If you own property other than real estate that has significant value, such as an RV or boat, and the asset is not financed, then your creditor might attempt to seize this property. This is not a common method for creditors to recover monies from debtors. Your creditor might have to pay a significant amount in fees to have a court-appointed official seize your property. Finally, your creditor will be reluctant to seize property if you have financed the property to be seized. If you feel that you have received value from watching this video, then I would ask you to hit the like button. Creditors are going to have a much more difficult time recovering monies from individuals who fall into one or more of the following buckets. Do not own real property. Support themselves on pension income or social assistance. Have a low-paying job or can switch jobs easily. Own very few assets in their own name and can take advantage of an exempt property provision in their province or territory. Do not have a bank account. The number one obstacle for creditors recovering monies from a debtor arises where the debtor is a renter. 32% of Canadians rent. If a creditor sues a renter and obtains a judgment, then the creditor is not in a position to put a lien on the debtor's real property. There are some Canadian homeowners watching this video with a deteriorating debt situation who might be better off selling their home and renting. Failure to do so might result in the future loss of some or all of your existing equity in the property. If you owe money on a department store credit card with a 28% interest rate and your creditor successfully sues you on that debt, then your creditor will likely be entitled to 28% interest on its judgment. The amount of money that you owe on a judgment with a high post-judgment rate of interest can snowball over a relatively short period of time. In some instances, a homeowner's entire equity can be wiped out in a few years. If you own a home and your financial situation is deteriorating, in order to protect the equity in your property, then it might be necessary for you to sell your property and then rent. As a practical matter, this might put you in a position to put the proceeds of the sale of your home beyond the reach of your creditors. Please note that there are laws to protect creditors in circumstances where a debtor that has become insolvent sells their home or transfers title to their property to a family member. Some sources of income are simply beyond the reach of your creditors. It is estimated that 5% of Canadians support themselves on social assistance. These social assistance payments include welfare, unemployment insurance benefits, and Canada Pension Plan payments. This income is not available to creditors. Creditors cannot garnish these payments. Furthermore, some Canadians receive benefits under company pension plans. As a general rule, these benefits are beyond the reach of creditors. Finally, if you have an annuity, then your income that you receive from your annuity is beyond the reach of your creditors. If you are a salaried employee and your creditor has obtained a judgment against you, then your creditor might be able to recover some monies from you utilizing a wage garnishment. Each province restricts the amount of money that your creditor is entitled to under a wage garnishment. There are a number of ways that you can terminate a wage garnishment. If your wages are being garnished, then you can terminate the wage garnishment by simply quitting your job and then looking for a new job elsewhere. This means that creditors are reluctant to sue individuals in a variety of scenarios because these individuals will quit their jobs upon learning of a wage garnishment. This includes persons with low-paying jobs, people who earn a significant percentage of their income in tips, and people whose occupation is in high demand, such as dental hygienists, who can easily change employers. Depending upon your finances, you might be in a position to negotiate a one-time lump sum settlement where your creditor agrees to accept a payment from you somewhere in the 50 to 90% range of your outstanding balance as settlement in full. A negotiated settlement would terminate the wage garnishment. If you want to learn how to settle one debt, there is a link in the description to a video series titled How to Save Money Settling One Debt. You can also terminate a wage garnishment by meeting with a licensed insolvency trustee and making a consumer proposal or filing for personal bankruptcy. Your RRSPs are beyond the reach of your creditors. As a general rule, company pensions are beyond the reach of your creditors. As a matter of public policy, Canadian governments do not want individuals in debt to be destitute. Accordingly, each province and territory in Canada has rules placing some assets beyond the reach of creditors. As a general rule, each province and territory provides an exemption for the following assets: a few $1,000s for clothing, household furnishings, and appliances, a few $1,000s for a motor vehicle, a few $1,000s for tools required to earn a living. Some provinces exempt some assets for farmers. Exemption for medical devices. If your creditor or creditors have obtained a judgment against you, then you should avoid having a bank account or keeping a significant amount of money in your bank account. If your creditor can identify the name of your financial institution and your branch location, then it is in a position to enlist the assistance of the courts to do a garnishment of your bank account. In this scenario, your creditor will be able to seize all the monies sitting in your bank account to satisfy an outstanding judgment. A special word of caution: if you owe monies to the Canada Revenue Agency, If you owe monies to the Canada Revenue Agency, it can arrange to freeze your bank account without even suing you. In a perfect world, your pay from your employer will not be deposited into an account at a financial institution. If you are paid by check, then you have a number of options. Firstly, you can cash your check at a check cashing outlet. Secondly, you might be able to have your pay deposited directly into a prepaid credit card obtained through a check cashing firm. You might be able to use a prepaid credit card as a substitute for a traditional bank account. Some prepaid credit cards permit the cardholder to pay recurring expenses using their prepaid credit card. Finally, if your spouse does not have any judgments against them, then it might be prudent to deposit your pay into your spouse's bank account at the earliest opportunity. In many marriages, one spouse will have debts and the other spouse will not have any debts. In this scenario, any assets that are acquired should be acquired in the name of the spouse without any debts. This will make it more difficult for creditors to seize assets acquired by a spouse with debts. In a perfect world, title to your home will only be in the name of the spouse without any debts or potential liabilities. If you feel that you have received some value from this video, then I would ask that you consider hitting both the subscribe button and the notification button. Your support means that more people will see this video. If you would like to learn how you might be able to avoid paying a debt due to the passage of time, then you will want to click on the video appearing on the screen.